How's it going? This is Sherrod Seward. I'm one of the lead intake attorneys and drafters at Innovative Immigration Law and Shared Sports Visas. And today I'm talking about more of a theoretical and philosophical way of thinking about creating O1 visa petitions. We do a lot of visa assistance for other attorneys and participate a lot in groups where there might be other attorneys asking questions about the O1s and EB1As and P1s, and we're glad to help. But there's one thing that I kind of want to talk about and address publicly and just put it out there for anyone to see, because I think that it's helpful to the industry and also helpful to getting more approvals for all the great folks out there trying to get O1 extraordinary ability visas. And that is, sometimes we'll do a consulting work for an attorney that doesn't do a lot of O1 visas, and it might be something to where they do a lot of family-based immigration, or even a better example is removal defense, where you end up in court a lot over these, and there ends up being a lot of cases and holdings and legalese arguments that get put into their briefs because that's what they're used to using. But a lot of times in these situations, the things that you're arguing for are more straightforward and not as subjective as the O1 visa category. If you don't know, like we know this is probably more appropriate for people that are already drafting or looking forward to do immigration law. You know that there's about 6 or maybe 7, depending on which category you're doing, O1A versus O1B, of criteria that there are, of which you have to prove 3. These criteria are usually pretty subjective. And then even when they're not, they are still adjudicated objectively by USCIS. And the long story short is the legal holdings and things like that just really don't hold water if USCIS doesn't want them to. So there can be a lot of effort spent trying to find and cite case laws for these eligibility criteria when USCIS flat out doesn't care, and it really doesn't like apply as much, you know. There are some circumstances like when it does, because one, there's just not a lot of litigation out there when it comes to O1 visa denials anyway. We've done some, and we've seen firsthand how just the subjective nature of the eligibility criterion just makes it problematic to pinpoint down on, like, you need to do this because of this holding over here, things of that nature. I mean, one case out there that is beneficial is if you're arguing for comparable evidence categories, and then you use the example where they had the national team coach whose pupil won a gold medal, then that can be helpful. But then even if they want to find subjective ways to differentiate that from your particular situation, they'll do that. That's why I think philosophically and on just the results, it's better to leave a lot of the legalese out and just make tangible, make sense arguments about the subjective categories. Supply it with context upon context upon context, rather than try to hammer it down in case law, because the time spent explaining why an original contribution is important just through finding research or getting some expert opinion letters is much more better spent than finding a case law about something that may be kind of the same, but maybe not, just because the eligibility categories are subjective, right? So it makes it easier for them to say no and differentiate from one circumstance that's much, a little bit different from another one, even though they might be kind of similar in concept. So that's why I always advocate for just bolstering your petition with common sense arguments and common sense supportive documents. So that way, if you do get to the point to where you are presenting a case in court, your record shows a lot of just common sense, copious amount of good information to show why this subjective category should have been approved. And even a lot of times we don't even like to adjudicate the cases where they find that eligibility requirements are not met, as opposed to if there's a structural contract issue or something like that, or if it's something obvious, like the coach was a national team coach of a bronze medalist, and it's well documented that he was instrumental to that success. But that's my 2 cents on the matter. Case law arguments in O1 visa petitions are not all that helpful. It's better to do common sense context arguments with outside information, just to make it clear as day to an adjudicator that might not want to get into the nitty-gritty of finding different holdings and stuff like that, and rather just say, like, this criteria is not met, and see what happens. Hope that's helpful. Hope you find some value in that, and I'll talk to you soon.